Good morning, all of you. Last we finished RTI, right? ठीक है. All right. Give a heading: debates related to right to life. Debates related to right to life. ये. Debates related to right to life. Right. Article 21. Article 21 of the Indian Constitution Article 21 of the Indian Constitution guarantees protection of life, and personal liberty. Protection of life and personal liberty. It declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, Article 21, which is considered as one of the articles which forms the Golden Triangle, 14, 19, and 21. In a way, it can be considered as one of the most important rights which has been given, because every other right become relevant only if Article 21 is ensured. लाइफ रहेगा तभी क्वालिटी की बात करोगे, लाइफ रहेगा तभी डिस्क्रिमिनेशन की बात करोगे, लाइफ रहेगा तभी अनटचेबिलिटी की बात करोगे. यदि यही नहीं रहे और सारी राइट्स दे दिए जाए कि भाई कोई अनटचेबिलिटी नहीं फॉलो करेगा, कोई डिस्क्रिमिनेट नहीं करेगा, कोई प्राइवेसी को हिंडर नहीं करेगा. So basically, this is the most fundamental. This is basic. In fact, when Hobbes is also giving very limited right, वो right to life को ensure करता है, isn't it? अब ये जो आर्टिकल है आपके सामने, सब हार्डली 2 लाइन का आर्टिकल है. नो पर्सन शैल बी डिप्राइव्ड ऑफ हिज लाइफ और पर्सनल लिबर्टी एक्सेप्ट अकॉर्डिंग टू प्रोसीजर एस्टैब्लिश्ड बाय लॉ. Now, when you read into this, it is saying that first of all, no person. That means it is available to non-citizens also. Otherwise, word citizens की करता है. Shall be deprived of his life or personal liberty except. Now, if the article would have ended here, that no person shall be deprived of his life or personal liberty, it would have been an absolute right. कि किसी भी सिचुएशन में आपके पर्सनल लिबर्टी और लाइफ को कॉम्प्रोमाइज नहीं किया जा सकता. बट द आर्टिकल इटसेल्फ इज गिविंग एक्सेप्शन दैट देयर कैन बी सर्टेन सिचुएशन व्हेन योर लाइफ कैन बी टेकन अवे और योर पर्सनल लिबर्टी कैन बी कॉम्प्रोमाइज्ड. But that situation is one situation which is provided in any particular law. When we started this chapter, हमने देखा था the literal interpretation and liberal interpretation. We saw the example of this, that when Article 21 is being interpreted, and when this matter came before the Supreme Court in the very famous A.K. Gopalan case. The background of this case was that a communist leader, A.K. Gopalan, he was put behind jails, behind bars, and he approached the Supreme Court saying that my personal liberty is being compromised, and it is being guaranteed by Article 21, which is a fundamental right. Now, the court read this article, and court said that first of all, it is not an absolute right, and there can be a situation. That means if there is any law which is providing for such executive action, then we will not be able to do anything, because when we will be doing judicial review, we will consider this law as truth, absolute मान के चलेंगे. And on the basis of that, we will see that whether this execution is allowed by the law or not. यानी हम केवल executive action का review करेंगे. We will not be reviewing the legislative action. हम मान के चलेंगे, हमने देखा भी था कि judicial review जो है, it has evolved into 3 ways. First, the judicial review was of executive actions, then of legislative actions, and then of even constitutional actions. So here judiciary said that our work is just, our work is limited. He will ask the police that is there any law on the basis of which you have put this person behind bars? If the police would be able to produce that law, then we will be satisfied by that particular law. And there was a Preventive Detention Act under which A.K. Gopalan was put behind the jail. And therefore the court said that it is absolutely कुछ एस्पेक्ट थे उस कानून के जिसमें एक एस्पेक्ट ये था कि it was not required to tell the reason for arrest, neither to the person who's getting arrested nor to the judiciary. Judiciary said that judiciary को बताना पड़ेगा, आप भले जो person arrested है उसको बताया ना. Otherwise that law is absolutely fine. But when this particular case, again question is again coming in the very famous Menka Gandhi case. When her passport has been taken, her personal liberty is being compromised. She's appearing, she's coming to the Supreme Court, and this judgment is a post-emergency judgment 1978. And we have seen that in post-emergency period, how the judiciary has gone for judicial activism. Because during the emergency, judiciary had seen that if we don't stand by our rights, then the executives, they are not going to treat us well. And there have been various bad judgments that judiciary has given during the emergency, and now is the time to go for activist fix. Now the same question being asked here, now judiciary is saying that when it comes to Article 21, we can apply the doctrine of due process of law. Because life, the term life mentioned here is not just animal existence. You are living, you are breathing in, breathing out. That is not life. Life means a life of dignity, a meaningful life. And therefore, they said that we can apply due process of law. अब ये जो doctrines हैं, we have the procedure established by law and we have the due process of law. It is similar to what we studied in Article 14, that is equality before law and equal protection of law. Basic idea दोनों का same. Here the focus is on the process. The process बराबर होना चाहिए. Equality before law. Procedure established by law. Here, law is important. Law is important. Judiciary follow करेगी procedure established by law, and there should be equality before law. दोनों term में law जो है वो primary importance उसको दिया गया है. And it means that there should be equal process, equal procedure for everything. But when we talk about these concepts, here the focus is when we say due process of law. Here the law is not primary. Here law is just the guiding light. और law से केवल objective लिया जा रहा है. और जो भी due process है, law आप judge क्या करेगा कि when he will read the law, he will understand that what is the objective of this. And for pursuing that objective, for achieving that objective, whatever due process he has to take, whatever process is required, that may be a bit different from what has been defined. The judge is having freedom to do that. Again, जैसे उस समय हमने कुछ example दिया था कि sometime even if you follow the same process, आप objective नहीं achieve कर पाते. Similarly, you can take the example that let us say somebody is traffic rules है. Traffic rule ये है कि when you are let us say there's a traffic light red है यहाँ पे, आपने उसको cross किया. Now let us assume कि यदि हम follow करते हैं, in this case if you are following procedure established by law, इसका मतलब होगा that there will be a challan of let us say 10,000. या फिर अभी जो सबसे कॉन्टेक्चुअल है वो है कि यदि आपके पास पोल्यूशन सर्टिफिकेट नहीं रहे गाड़ी का, परसों दिन ही बनवाया, मेरा एक्सपायर हो गया, ठीक. हाँ, सर्टिफिकेट बनवाने में 85 रुपया लगता है और यदि पकड़े गए तो 10,000 रुपया का चालान. और आई डोंट नो व्हाट द रियलिटी इज, लेकिन मेरा फ्रेंड एक बता रहा था, झूठ भी बोलता है वो, लेकिन तो वो बता रहा था कि बट आई कुड बिलीव हिम बिकॉज ही इज वर्किंग फॉर सस्टेनेबिलिटी, गवर्नमेंट के लिए काम करता है, ठीक है. अभी वो 2 दिन पहले इजराइल से आया है, वहाँ पे काफी सस्टेनेबल वाटर को कैसे वो सब सीख के आया है, और वो एक इतना छोटा सा एक पैच लेके आया, हमको कल दिखा रहा था कि देखो ये मोसाद ने दिया है हमको. हमने कहा कि तो बचपन में ऐसे ही कहानी सुनाते थे कि इसमें पावर है, और अभी तो ये सब खरीद लिया वहाँ से नहीं तो चांदनी चौक में सारा मोसाद ऐसा ही सबका मिलता है, ठीक है. तो एनीवे, तो ही टोल्ड कि द पुलिस इज हैविंग सम द इंस्ट्रूमेंट दैट दे आर हैविंग, कि आपका पोल्यूशन अंडर जो पीयूसी सर्टिफिकेट फेल्ड है तो पहले से पता चल जाता है, गाड़ी अप्रोच कर रही होती है, आई डोंट नो, ठीक है. एनीवे, तो इसका एग्जांपल लेते हैं. तो लेट अस से द चालान इज 10,000. ओके, नाउ इफ यू आर टेकिंग द सेम अमाउंट फ्रॉम एवरीबॉडी, ठीक है, यू आर टेकिंग द सेम अमाउंट फ्रॉम लेट अस से अ पर्सन हु इज जो कि ओला उबर चला रहा है, ठीक है, जिसका मान के चलो कि पर डे द एक्चुअल इनकम इज आफ्टर डिडक्टिंग एवरीथिंग लेट अस से कि वो 1,000 है, ठीक है, जस्ट इमेजिन, ठीक है. और सेम चलान आप कर रहे हैं, मुकेश अंबानी की भी गाड़ी पकड़ी जाती है तो आप 10,000 ही लेते हैं. नाउ विल इट सॉल्व द प्रॉब्लम? नो, बिकॉज अब इनकी गाड़ी है तो 10,000 या जितने दिन में तुम चलान की बात करोगे उतने में कितना होता है, जितना दिन में पैसा उठाएगा उतना में उतना लाख कमा लेता है, कुछ समथिंग लाइक दैट. तो बल्कि वो जैसे ही रुकेगा वो नहीं पूछेगा कौन सा चलान, कितना अमाउंट है, लो ये लो, डोंट वेस्ट माय टाइम. और वो नहीं बनाएगा चलान, अगले दिन भी वो ही डज नॉट माइंड पेइंग एवरी डे 10,000 रुपीस, दैट इज नॉट अ वेरी बिग थिंग फॉर हिम. बट ये इंसान जिसको 10,000 का चलान देना पड़ा, इसकी तो 10 दिन की सैलरी उसमें चली गई, तो ये तो मतलब कि जब चलान वो सर्टिफिकेट फेल होने वाला है उसे 1 महीना पहले बना के रख लेगा, ठीक है. बट अगेन द थिंग इज इट इज नॉट अचीविंग द ऑब्जेक्टिव. Why? Because you are following procedure established by law, equal process for everyone, equality before law, जो कि ब्रिटिश ट्रेडिशन है. But यदि सेम चीज आप फॉलो करते हैं, the due process of law, then you will be thinking that what is the objective of this law? Objective of this law is that everybody should keep their vehicle within the controlled limit of pollution. In that case, what will happen? कि maybe a person who is driving Uber, उसके लिए चलान है 500 rupees, उसके आप की सैलरी उसमें चली जा रही है, प्रॉफिट चला जा रहा है, तो ऑब्जेक्टिव अचीव हो जाएगा. He will not let it fail. And इनके लिए आप कर दो कुछ तो 1 करोड़ कर दो, कुछ तो कर दो 1 करोड़, तो थोड़ा सा तो हिट करेगा कि भाई नहीं 1 करोड़ रुपए जमा किया, तो दोनों के पास ऑब्जेक्टिव क्या होगा, दोनों the objective will be fulfilled. So this is what Article 21, when it was liberally interpreted by the Supreme Court, it said. In A.K. Gopalan, they said that we will review only the executive action. Law को हम सही मान लेंगे. In Menka Gandhi, they said that we will review executive as well as the legislative action. कि क्या पता कानून ही ठीक नहीं, जिसको हम सही मान के आप judicial review कर रहे हैं. What if the law is not good? So we will keep constitution as the parameter and we will review even the, and thereby they expanded the scope of Article 21. So much so that many other components have been included in right to life. Right to life में राइट टू क्लीन एनवायरमेंट भी है, ठीक है, आगे चल के राइट टू प्राइवेसी भी इंक्लूड किया जाता है. इनफैक्ट यू हैव राइट टू स्लीप आल्सो, यदि आप सोए कोई जगह है आप सीधे सुप्रीम कोर्ट उठ के चले जाओ, ठीक है, हमें सोते हुए जगह दिया तो हमारे फंडामेंटल राइट को वायलेट कर. सो अगेन इज अ लिबरल इंटरप्रिटेशन, ठीक है, अनदरवाइज, बट यस आर्टिकल 21 रिमेंस अनपावरफुल. तो ये ऑब्जर्वेशन लिखेंगे. नेक्स्ट पैराग्राफ. द सुप्रीम कोर्ट इन A.K. Gopalan case, in A.K. Gopalan case 1951 gave, sorry, it was 1950, A.K. Gopalan case 1950, gave literal interpretation of Article 21 declaring that the protection of Article 21 is available only against arbitrary executive action and not against arbitrary legislative action. Next paragraph. However, in Menka Gandhi case, 1978, the Supreme Court declared that the law should be reasonable, fair, and just. It introduced the American doctrine of due process of law. The court said
अच्छा था वो तो खा लिया, मैंने नहीं खाया था ज्यादा,
अब भी बताओ
that the term life
थोड़ा सा रखा था कल।
तो बनाऊं अब
the term life mentioned
तो
in Article 21 does not mean